All right, counsel, the rebuttal time is set at 5 minutes. Would you like something other than that, or is that okay?
5 minutes is great, Your Honor. Thank you.
Good, thank you, sir. You may proceed when you're ready.
May it please the court, Elliot Shurker on behalf of City National Bank. Signature Land's principal, Stephen Leggett, sought to rezone City National's trust property for his own benefit because he wanted to buy and develop the property, and the political winds were right, he believed, for rezoning the property for residential development. He acted at his own risk, as he acknowledged to trust beneficiary Leonard Abbas, quoting from the record at 2256, "If for any unforeseen reason we are not able to continue, I will walk away from this project with no argument about the costs I have incurred, and City National's property will have an added value free of charge."
At what point was that?
That was in April of 2015.
No, don't give me a date. Give me the timeline. That was after. It seems like that was written pretty late in the process.
That's correct, Your Honor.
Yeah.
That's when Leggett was trying to buy the property, insisting that he pay the pre-rezoning price of $6 million from 2013.
Yeah, that was after the rezoning had already occurred.
That's correct, Your Honor.
Okay, all right. So maybe not as helpful for you as if it had been stated well before the rezoning.
There was no contact before the rezoning.
Well, I'm just saying that would help your case a lot more if it was much earlier, correct? Do you agree?
Well, my point, Your Honor, is he has it exactly right. This was an unrequested benefit conferred voluntarily for Leggett's own benefit. And the question on this appeal...
Well, they anticipated, I mean, it was at least... there was an anticipation that there would be a sale of the property, right? I mean, at least on his part.
Completely unilateral, Your Honor.
Okay.
The deal fell apart when he couldn't finance it in 2013. And there was no contact between Signature Land and the beneficiaries. Instead, Leggett and Ruckman, the real estate broker, went off on their own, submitted an application in City National's name.
Let's assume for a moment, just theoretical question. Let's assume for a moment that Ruckman was at least an apparent agent. Okay, let's just assume that for a moment. Then now, what was it done without contact? Then you said it was done without any contact with the beneficiaries. But if Ruckman was an apparent agent, then that's no longer true, correct?
If Ruckman was an apparent agent, they have a lot better case. But the testimony from Leggett, was that we did nothing. The beneficiaries did nothing to constitute Ruckman as an apparent agent. What he said was that neither City National nor the beneficiaries made any representation to create an appearance of Ruckman's authority to act for City National. That's transcript volume 2 at pages 189 through 90. Nor, more importantly, did he rely on any representations by City National regarding Ruckman's authority. And Ruckman told him, and this is also undisputed, that he had no authority to sign the application. So there's no basis for apparent agency whatsoever. Of course, that would change the case considerably, but there's no basis for apparent agency.
If there was apparent agency, then, so I understand what you're saying, fair enough. But if there were apparent agency in this case, right, then how would the analysis go as far as an unjust enrichment claim? I mean, I could still imagine a situation where Ruckman says, hey, do what you want, you know, I don't know if we'll come to a deal or not. Maybe we will, maybe we won't. But do, you know, at your own risk. And it seems like in that situation that there would not be a claim for unjust enrichment. Do you agree?
If Ruckman was the agent, apparent or otherwise,
right.
There's no claim of actual agency,
Correct.
Of course. If he was the agent, apparent or otherwise, that would definitely shine a different light, and there's no question about that.
But I'm saying even then, you wouldn't necessarily have an unjust enrichment claim, or would you? Right.
Actually, Your Honor,
you think you would? So if Ruckman says, hey, go ahead, do it at your own risk, though, because I don't know if we're going to have a deal. But if you want to do that at your own risk, hoping that there is a deal, go ahead. You think there's an unjust enrichment claim?
Yes, Your Honor, I do.
Okay.
Leggett was acting on his own hook. In his own words, he was gambling. He says, that's what I do for a living. And he was gambling that he'd be able to go back to the beneficiaries and say, please sell me the property. at the original price. Now, the letter I was quoting from at 2256, the email letter, is rather a rather extensive history that Mr. Leggett sends. It's not just a one-word dash-off or one-paragraph dash-off of an email. This was dated April 22nd, 2015, and it's directed to the beneficiaries. It goes through the entire history of what he was doing. And what he says in so many words is, I went ahead and started the rezoning process. Potential investors wanted the zoning in place. I take an active role in Jacksonville politics. Our district councilman indicated that he could support the project, but he was going to be term limited. With the rezoning process taking 4 months, I knew we needed to get started. He said further, 2255, I honestly was never concerned about the fact that we didn't have a signed contract because I continued to work with Ruckman on the project, and we believed the price in the previous agreement would be acceptable, with no indication whatsoever that that was true as to the beneficiaries. It was 2 years later, and there was no indication whatsoever. I respectfully ask you to honor the negotiated price. What he wanted to do was this: get the property improved with the rezoning, then buy it for the 2013 price. And he insisted on, and then he also said in the same letter, however, that if you want to go and get appraisals, that's fine with me. If you agree, I will pay the highest amount of either of the two appraisals with the negotiated price. That was his offer to the beneficiaries, and they went out and had it appraised and then offered to sell it for $8.5 million. So we took him at his word and said, fine, here's the appraised price. He refused. So his deal is this: sell me the property for $6.5 million, as I could have bought it in 2013. I get the benefit of the higher value of the property, of approximately $2.5 million, which is what he got out of the jury, for the simple cost of what it cost me to do it, and that's never been proved. They never sought that as damages. Or if you don't, I'm going to sue you for unjust enrichment and get the same $2.5 million. It was a heads I win, tails you lose.
Talk to us briefly about the effect. So you say that there's no apparent agency, and you make that point for the entire timeline, but talk to us about the effect once you had notice that he was doing this, that Ruckman had signed as the owner to give him the ability to do this, and you didn't put the brakes on it.
Yes, Your Honor, that's a fair question. This is putting the onus on the innocent recipient who receives some notice. Now, there was different notice at different times, and we need to be precise. What happened was initially a form notice went out from the city of Jacksonville to City National Bank. It ended up at the bank, and that's the end of what the testimony is as to who knew what. Now, everybody agrees this is a Florida land trust, and of course my opponents rely most heavily on what the beneficiaries knew and said. So I don't think they can get very far with that piece of paper living in the bank. The second thing that happened was Ruckman, on his own hook, went to the other family involved in this, the Tredenicks, who everybody knew wanted to sell this property, and that's the only reason the trustees were selling the property in the first place in 2013, was because the Tredenicks needed to monetize the property. He went to the Tredenicks to try to convince them to authorize the trustee to do the sale and to sign off on this contract that nobody else ever saw. Now, what the undisputed testimony from the Tredenicks was, everybody knew, and I'm sure my opponents will concede, that Mr. Abbas spoke for the trustees, that he was the representative of the trustees. And the testimony from the Trednick family was, no one came to us. Don Ruckman, who'd been working with the Abbas family for 40 years, never came to us with any offer or any deal that hadn't gone through Mr. Abbas. So when he came to us with this, we assumed that Mr. Abbas had approved it, and the email traffic afterwards shows that that's absolutely true. So the notice, if you will, of what was going on was not in the form of, we are rezoning your property and we would like to buy that property at the 2013 price. Nothing like that ever happened. And when Mr. Abbas found out, his shock and surprise is clear on the face of the record in his testimony and in the contemporaneous documentation. That he was stunned that somehow Don Ruckman had gotten together with Leggett to do this.
Before the rezoning occurred, did they find out before?
Before the rezoning, yes.
Yes, they did. So I guess that's the question, right? What did they do then?
That's the second part of the answer to the question. The second part of the answer is there is no authority cited in their brief or anywhere that I can find for the proposition that an innocent recipient of an unsought benefit is required to go into their own pocket.
Talking about the appellee's brief?
Nor in their brief.
The appellee doesn't have a burden on appeal, do they?
They have to show they're right. There's no authority for the proposition.
Don't we presume that the trial court's order is correct?
This is a legal question, Your Honor.
Okay.
Is this unjust? Is one who is conferred a supposed benefit unilaterally and voluntarily by an officious intermeddler required to throw themselves in the path, if you will, of the unjust of the claimant's of the claim?
Does your client accept and retain the benefit?
Our client still owns the property, yes, Your Honor.
Did your client defend the rezoning?
That's correct.
Okay. Could that be viewed as acceptance and retention of the conferred benefit?
We have to look at the circumstances to answer that question.
Okay.
What we were told was two things by Leggett and Ruckman. We were told, first of all, the part that I read at the beginning of this, of my argument, if we don't have a deal, I'm walking away. So we knew that. We also knew, because Ruckman was importuning the Trednicks, who he knew wanted to sell the property. This is what's going to happen. We have unleashed a firestorm, that's their own words, of opposition to this project. Citizens were up in arms about the rezoning, and we're fighting to oppose it. If you lose...
I understand there may be reasons why they felt that they wanted to or needed to accept and retain the benefit. I get that, but does that change the fact that they accepted and retained the benefit?
Your Honor, I'm more specifically answering the question of their defense of the rezoning.
Right.
They were being told that if you lose, this will affect the value of your properties.
Read that in the record. I understand.
So the question, was this a voluntary, the unjust enrichment question, was this a voluntary acceptance, or was this playing the hand that was dealt by the officious intermeddler? If I'm selling my house...
Fair enough. So when you point out that, well, okay, so you have the defending it afterwards, but then you also have that you knew before the rezoning occurred, and you didn't jump, not you, obviously, your clients didn't jump in to say, hey, stop, right? So when you put the two together, why is that not competent, at least competent substantial evidence for the fact finder to say, hey, you accepted and retained the benefit?
We submit it's a legal question, Your Honor.
Okay.
Which is why we're comfortable bringing it before this court after a jury trial. The legal question is, does a property owner who becomes aware of an unrequested, unsolicited benefit have an obligation to leap in and stop the activities of the officious intermeddler? And we rely in particular on Judge Posner's example that we quote in the reply brief of sitting on your back porch, having an afternoon drink, and itinerant musicians come up and entertain you, and then when you decide not to pay them, run to court and claim they unjustly enriched you. Well, you knew that they were conferring a benefit on you. They were providing you a very pleasant afternoon. Are you required to jump out and say, stop? And I can't find any authority for that proposition. It goes to the question of voluntary acceptance as opposed to knowledge. If I'm, as I started to say, if I'm selling my house and someone who wants to buy my house while I'm out of town plants a bunch of very valuable trees on the property and then says, I'll buy your house at the asking price, but I'm not going to pay you for the increased value that I just conferred. And I say, no, I don't want to do that. I'll sell it to you for the increased value, but I'm not going to sell it at the value that it was before you voluntarily conferred this benefit on me. And the answer to that is, well, then fine, I get you the other way and I sue you for unjust enrichment. I create what I believe we fairly call a Hobson's choice. Either you sell me the property at a reduced price, not what it's worth, or it's an unjust enrichment claim. And we submit that's not the stuff of which an unjust
Rely
enrichment.
heavily on the restatement, the third.
I do, Your Honor.
The third restatement, correct?
I do, Your Honor.
I didn't see any any Florida case adopting the third restatement. Not that that's dispositive, but it certainly would be of interest. Did I miss one?
We cite at least 4 cases
Right.
in which the restatement is looked to by the Florida courts. There's no Florida Supreme Court case that expressly adopts the restatement as the law of Florida, but the courts frequently look to the restatement, and we submit these are basic unjust enrichment principles. And we particularly commend Section 30, Comment C, which expressly addresses exactly this situation. And the only case we can find in the country on this is the case from Idaho that we cited in our brief, where a party voluntarily rezoned property and then claimed unjust enrichment when, because of a boundary dispute, it ended up the neighbor's property. They said, you voluntarily rezoned it, no one asked you to do it, and you don't get the benefit, you don't get to recover the benefit of doing that. I'm aware that I'm at my rebuttal time, Judge Harris, but I would like to touch on damages before I sit down. If I use up my time, then so be it. We submit that unjust enrichment damages under Florida law, even if liability stands, do not authorize the jury's award. The jury rejected the plaintiff's claim. The plaintiff's claim is that the property was worth $3.5 million before rezoning and was worth $9 million after the rezoning. And they requested $5.5 million. The jury rejected that and awarded approximately $2.5 million, which was the difference between the offering price in 2013, which plaintiffs concede at record 1561 was not the value of the property, and the offering price, the unaccepted offer in 2015, which Florida law says is not a marker of value. So we have 2 non-markers of value that the jury selected on its own as establishing the $2.5 million in damages. We rely on this court's decision in American Safety. Damages cannot be based on speculation, conjecture, or guesswork in an unjust enrichment case as in any other case. The only other point I'd like to make on damages before I sit down and rely on my brief for the rest of the argument is that Leggett testified that he had an investor. He couldn't close without this investor. He needed a huge cash infusion to close. And he had no operating agreement with the investor, Mr. Sorensen, at all. He said his share of the ultimate deal could be 50%, could be as little as 25% if they ever came to an operating agreement. He recovered the entire $2.5 million, which he never would have gotten had he done the deal that would have allowed him to buy the property. That's exactly the 3rd DCA Alvarez case, where a 50-50 split was created out of whole cloth, and they could not recover those damages. Again, complete and total failure to prove any damages, even if the liability verdict can stand. Thank you very much.
All right, thank you, sir. All right, sir, you'll have 20 minutes for your argument, which will include any issues raised in your cross appeal as well, okay?
May I review any time for rebuttal only on the cross appeal issue?
Just the 20 minutes, okay?
All right, thank you, Your Honor. May it please the court, my name is Jeffrey Regan of Regan Atwood, Jacksonville, Florida. I have with me at council table today Mr. Charles Walker of Bloodworth Flick and Walker in Orlando, and in the courtroom today is Mr. Stephen Leggett, who is the client representative of the appellees in this case.
Counsel, I'm not sure the question is as important, given your opposing counsel's argument, but under the sort of the elements of unjust enrichment, if we had a situation where you were the owner of a property and I came to you and I said, hey, I know that I don't know if we'll have a deal or not. You won't tell me there's going to be a deal, but gee, I really hope that you and I can come to a deal, but I need to make some improvements because of time issues, and I'm just going to do that. And I understand that it's at my own risk. How would that meet the third element? It would be inequitable for the defendant to retain the benefit without paying for it.
Yes, sir, and I understood that's the fourth benefit, that it really would be inequitable or unjust.
How would it be unjust when I've said, hey, I understand I'm totally on me, and I understand I'm totally taking a risk here, and you're not agreeing to anything, but I'm just going to do this because I'm hoping on hope, right? How is that inequitable at that point?
Under those facts that you've stated, that may not be unequitable. That's not even remotely similar to the facts of this case.
Give me 1 minute on why not, or 45 seconds.
On the facts of
On this case, right. Mhm.
Okay, the issues on this case is there had been a fully negotiated contract for $6,025,000 that did not close. There had been contracts for the exact same amount that the parties had written out that simply hadn't been signed, and the representations had always been, you're going to get the deal for the $6,025,000. So it's not the analogy that you put up, which would be an imperfect analogy.
You're talking about
It is much different.
representations from Ruckman?
Yes, sir, Ruckman. But it goes beyond Ruckman, because the Trednicks, who were people with the power of direction to tell this trustee, you have to sell this property for $6,025,000, knew the rezoning was going on, had the notice of rezoning from the city in their records, had even signed the direction to the trustee to sign the contract for $6,025,000, and were fully aware of that zoning going on. They complain, all of their arguments is the jury should have come up with a different decision. What they have to establish is, as a matter of law, all of those facts were irrelevant for the jury, and that they shouldn't have been concerned. Trednick knew that. Similarly, the person with the power of direction, Mr. Abbas, knew about it before the rezoning came down, and he knew about the contract. It's undisputed in the record that Mr. Ruckman sent him the full zoning application with all the pricing. He laid it down all before the zoning was done. Mr. Abbas, who is active with the University of Miami, received an email from a professor at University of Miami saying, I'm forwarding an email from another person to you because you may not know what's going on with your land in Jacksonville. There is going to be, it was a preliminary hearing, but a preliminary hearing tonight. He wants to talk to you to make sure you know what's going on. What did Mr. Abbas do? At that particular point in time, he was charged with all knowledge. The expectation was $6,025,000. We were going to sell it after the rezoning of this property for that dollar amount. He knew all about the rezoning application. He knew there was a hearing coming up. And what did he do with the email? He forwards it to Mr. Ruckman saying, I'm not going to call him. I'm not going to do anything about it. He was fully apprised before any rezoning occurred, both of the parties with the power of direction. Those facts overwhelmingly support the jury's verdict here on the facts that there was knowledge that this was being done by the parties. That's element number, first, element number one, they've never contested a benefit was conferred. It doubled the number of lots. Element number two, the defendants have knowledge of the benefit. Well, I just told you why the persons who can tell the trustee what you have to do had knowledge, and our briefs go through why under a land trust their knowledge must be imputed to the trustee. But if we look at the facts here, the trustee had knowledge. The trustee at least was given the knowledge whether they wanted to look at it. It's undisputed in the record that the city of Jacksonville sent not one, not two, but 3 notices of the very first preliminary rezoning meeting that would occur on this property to the trustee in Miami, Florida. 3 of them were sent to them. They were mailed at least 2 weeks before that prior hearing. That notice was also in the Trednick's records. The jury could easily have inferred that the Trednicks got that notice of the rezoning that is in their corporate records from where? From the trustee it was sent to.
Why don't you briefly talk to us about apparent authority? What evidence, what's the best evidence to support the apparent authority issue?
Right. The best evidence of the apparent authority begins with the 2013 contract. The evidence at this trial was that Mr. Ruckman was the only representative of the trust in Jacksonville, Florida. He was the only person that managed the trust and the trust property in Jacksonville, Florida. He was paid a monthly management fee to do so on that property. He was the only person that you could contact, the only person you were allowed to speak with even about any potential purchase of this property was Mr. Ruckman. He was the only person that did any of the negotiations of the 2013 contract with Mr. Leggett. The negotiations and representations he made with Mr. Leggett under that contract were approved by the beneficiaries having the power of direction and then signed off on by the trustee. They went up to the closing, and then Mr. Leggett couldn't fund it and he defaulted. After he defaulted, the attorney for the trust who was going to do the closing sent a letter out, we're taking your $200,000 deposit because you've defaulted. If your circumstances, meaning your financial circumstances, change, contact Mr. Ruckman. That's what it says in the letter that's in evidence to them. So what did he do? He did just that. He contacted Mr. Ruckman. And then they went through this whole series for another year in which they talked about the property, and Mr. Ruckman said, when you get another investor, we'll go to close the property. He did get another investor, Mr. Robin Sorensen, the founder of Subway sandwiches, of that huge national franchise, was going to be his other investor. And he also determined that the city council was going to change, and the councilman who supported this rezoning was going to be getting term limited out. So he said, why don't we do it now? Mr. Ruckman said it's a great idea, so they went forward to it. So Ruckman has all of the knowledge. They go forward with the rezoning. All of that gets sent to the trustee. It all ends up in the beneficiary's records. Both of the beneficiaries with the power of direction know all of the facts, everything, before any passage of this rezoning. While there's still just preliminary hearings going on, they do nothing. They stand by and do nothing. They don't call the city of Jacksonville and say, hey, city of Jacksonville, Mr. Ruckman didn't have authority to sign that. He shouldn't have done that. Stop the rezoning. They didn't ask, at least defer the rezoning hearings for another hearing. There was testimony at the trial from Mr. Leggett. They deferred it once before when they found out how much public opposition there was going to be. Everybody wanted to regroup and figure out how to deal with it, okay?
So
none of those things were going.
Opposing counsel says this is a pure legal question, and that you are asking us to create a legal onus where one doesn't exist for them to have to intervene and stop what was happening. Can you address that for us?
Yes, sir. I don't think that that's a legal issue at all that's required that you intervene. The elements of unjust enrichment are simply that a benefit's conferred uncontested, that you have knowledge. We've established there is knowledge so many different ways here before it was done. And then there is the acceptance element of this, and there's the unjust element of it, okay? And so the jury has to determine what is unjust. And this goes to the damages issues raised too, okay? The jury has a factual decision to say, was it unjust that they didn't contact them or not? Is it unjust that did they have enough time or not? Those are all issues for the jury. They're asking this court to fundamentally rewrite decades of unjust enrichment law, of common law that's existed in this state. I don't believe that that's appropriate at all. This is fundamentally a jury issue, and that's what it comes down to. They knew about it, they took advantage of it. And it goes on the damages side, because I want to address the damages with respect to that issue and saying, well, there was no damages on it. They actually requested a fifth element. These are standard Supreme Court approved jury instructions on unjust enrichment that were used in this case. They convinced the trial court to add, in essence, a fifth element, which is you have to take into consideration the expectations of the plaintiff in this case. What did they really expect, okay? In the analogy you gave that you just volunteered to do it, you don't expect to get anything. Oh, you just go to somebody's property, you improve it, saying, I'm just going to do this, I don't know if you'll agree with it or not. There was an expectation here. There was an expectation here, I am going to actually buy this property. I'm going to get it for $6 million, and I'm going to get some of the benefit of this rezoning, okay? And so that goes to that whole unjust rich element that exists on that. So the jury had all of that evidence, and they were allowed to weigh it, and they were allowed to argue it, which they did to the jury, but the jury just simply didn't accept it. So what I would say, Your Honor, is that what they're requesting this court to do is just fundamentally change the law. There is no basis to do that. It's in the elements. Did you accept the benefit? And even if you accept the benefit, the jury doesn't have to give you that increased benefit. They can say, under all the facts and circumstances, we don't think it's just that you get it. And that is one of the four elements that goes to the jury. That's not a matter of law issue for the court. I will say there certainly could be some circumstances under which that might rise to a legal issue. For example, in the Montage versus Athlete Tech case that was cited to it, and it's much different than our case here, okay? There was a joint venture, and the lost profits from the illegal use of the computer source code, the plaintiff only owned 50%. The plaintiff in this case is Signature Land and Edward Creek Signature. Those are the plaintiffs in the case. They're corporations. They're not the individuals. In the Montage case that was cited to, The plaintiff in that case was the actual owner of the only 50%. They were the same identity, which is different from this case. And the court very correctly in that case said, under the facts and circumstances of that particular case, it's not unjust. Okay, you have to reduce them. The lost profits are 100% of the profits, but he only owned 50% of the 100 of profits as the plaintiff. That makes sense. But the court followed the same law that has existed for decades in this state. That is a jury issue. It goes to the jury. And it comes down to the unjust argument. So what they want you to do is to take away from the jury whether or not the enrichment is unjust. And touching on the damages issue for that, okay, and they're arguing that where do you come up with $2,475,000? Well, that's a determination with mathematical exactness, and the jury hit it right dead on. When they asked for the instruction that the jury should consider the expectations of the plaintiffs, that is simply a supplement to the fourth element. Is it unjust? Consider their expectations when you determine that the increased value to the owner becomes unjust. They argued throughout the case the $6,025,000 should have been set as a floor. Well, guess what? The jury agreed with them. Okay, and they set that as their floor. The prior purchase price of $6,025,000 is the floor. Now, damages in unjust enrichment, unless it's unjust or unfair under the fourth element, and the jury will let you know that, is measured from the perspective of the increase in value to the owner. And Ron Moody testified the increase in this value was $3.5 million up to $9 million. It's $5.5 million. Which obviously showed that the plaintiffs were going to be overpaying for this property at $6,025,000, which the jury accepted as the floor, and that the value was 9, but it's to the perspective of the owner. It's from their perspective, the damages. And so, in doing that, the jury has to come back and say, well, it may be $5.5 million, but he was going to overpay for some of the property and take the risk of some of the rezoning in it apparently already. Okay, and we're not going to say that it should be between $6,025,000 and $9 million, because what did the owner tell us? The owner on April 15, 2025, sent a letter saying, we will sell you the property for $8.5 million. That's $2,475,000, the exact jury's verdict difference.
That doesn't establish the value, does it?
That does not establish the value in terms of a market value, Your Honor, correct. What that establishes is evidence of the increase in the value to the owner, which is the perspective from which you must measure the damages under the case law, unless it's unjust. And so you make all the arguments that have been made today.
So you're
make
saying,
all the arguments that were made at trial.
To the owner, when you say value to the owner, you interpret that as sort of a subjective, the owner sees this value. You don't read that as the market value has increased.
That is correct. The market value is certainly relevant, Your Honor, because it can establish in a marketplace, you know, perhaps what the maximum amount of the damages could be. But the fourth element is that the benefit conferred is unjust. The jury has to take into consideration all sorts of things. And in this particular case, knowing he was going to pay $6,025,000, they didn't have to, they say, well, then it's not unjust. He was going to overpay, so that'll be his floor. So when they come back and say, we'll take $8.5 million, well, they didn't have to accept the appraisers that it should be the difference between 9 and $6,025,000. They could take the 8.5 because that's what the owner felt the increase based on the rezoning. That's not disputed. That price was based on this rezoning benefit, according to the testimony of the trustees' representatives at trial. Okay, so they could do that. Interestingly, what is in that letter from April 25? The benefit to the owner of that property increased to them because they thought the property was worth $6,025,000 when the appraiser said it wasn't even worth $4 million before the rezoning. Okay, but they thought it was worth much more. But that was the increase in value, the $2,475,000. With the potential of a zoning appeal still in place. What they said is the value is 8.5, that's what you have to pass, and you're going to assume an appeal, you're going to assume any appeal or intervene in any appeal if that's what you want to do.
If you're calculating damages based from the perspective of the owner's gain and not what the not what you're out in this case. How
That is
how do you
correct.
justify prejudgment interest?
How do I, well, that was the next thing I was going to segue into. Under the Bosa versus Musa holding cases, which just reiterated any number of prior Florida Supreme Court cases in this. In fact, if you go through the Bosa case and then look at all the history, it takes it all the way back to the late 1800s, that the Florida Supreme Court, Florida Supreme Court has awarded prejudgment interest in contract cases or cases in the nature of contract or business disputes for over 100 years in this particular state. It is to, as the court explains in Bosa, Florida is a loss theory state. This is not meant to be punitive. This is not something where an award of prejudgment interest would be a windfall to the plaintiff. They use the term, he had no out-of-pocket expenses here. And obviously the case law uses as a shorthand phrase, you're entitled to prejudgment interest on your out-of-pocket expenses. But in Bosa, the Supreme Court goes further than that. They say, well, once the jury liquidates your amount due as of a time certain, that was the date you suffered your loss. Whether it was directly money you paid or not, it's the functional equivalent at that time. Because that you were out of pocket as of that date. And so in order to get the time value of your money, you need to get the prejudgment interest on that. And that was all that was asked for here. It was 7 years between April of 2015, when they said now the price is $8.5 million, which clearly signals we've accepted the benefit. It's $2.475 million increased benefit to us, was on that specific date when they communicated that letter. We would say as a matter of law that's the date. If not, it should have gone to the jury, but they convinced the judge not to let the jury answer an interrogatory verdict on the date of loss. And that's invited error. They can't complain about that now. So what is fair to Mr. Leggett, Mr. Leggett's companies, of his two companies out there, is to give him the time value of the money. The precedent that is created if you don't do that is you encourage the defendants out there to keep benefits and to argue and delay because they get the time value of that. That, for all we know, and while this didn't happen, after there was no closing and this fell through, they could have sold the property to somebody else for $8.5 million, and then they could have used that $8.5 million to invest it and make more money because it's got a time value to it. Or they could have just sat on the land like they did, and they could turn around and sell it the day after this appeal is decided if they lose it. And they could sell it for whatever today's market rates are, and they're getting the time value of the improvement that was made back in 2015 because of that zoning. So to not award prejudgment interest in this case, in our view, is being punitive to the plaintiffs and the appellees in this case. What we would ask the court to do is to affirm the verdict, the jury's verdict below, but to reverse for entry of prejudgment interest from the date of that April 15, 2015 letter when all of the elements of unjust enrichment had occurred, or remand it for the court to enter an award of the prejudgment interest. Thank you.
Thank you. All right, 2 minutes 20.
Thank you, Your Honor. Had we sold the property for $6 million as Leggett demanded, he would have received the benefit of the increased value of the property for essentially the cost of obtaining the rezoning. When we didn't sell him the property for $6 million, he recovered the same amount from the jury. That doesn't sound like unjust enrichment. The principle upon which we rely is in Section 30, Comment C of the restatement, if I might. If benefits were conferred before a promise of counterperformance, and you can listen to my opponent's argument, there never was a promise of counterperformance, had been obtained in the context of a prospective exchange that the recipient was still free to reject, the result is a form of uncompensated enrichment that is neither unjust nor unjustified. That's exactly what happened here. There was no promise of counterperformance. Signature went and attempted to rezone the property on its own hook for its own benefit. Very briefly on damages, you heard no response in my opponent's argument to our reliance on the third DCA Alvarez decision and the proposition that Leggett couldn't close without a huge cash infusion, and if he'd gotten that huge cash infusion, his share of it could have been as little as 25%, yet he recovered the entire value that the jury awarded. On prejudgment interest, there's no out-of-pocket loss. There's no loss at all. What was awarded by the jury was the supposed benefit, and they can't really have it both ways. They claim they conferred a benefit, and they're entitled to recover the amount of that benefit as determined by the jury, and yet want a date of unknown provenance to calculate prejudgment interest. There's neither a loss nor a fixed date. There's no invited error here. The trial court was entirely correct, and I'll note the cross appeal does not argue that the trial court was wrong in not instructing the jury to fix a date of loss, and the reason is there was no date of loss to be fixed and no basis for an award of prejudgment interest. Thank you.
All right, thank you both very much for a very well-briefed and well-argued appeal. It's time the court stands in recess. All right.